one reason why we have a separate person as set law to that of a trustee is to bind the conscience of the trustee, but it's very hard for a person to bind his own conscience. At least equity thinks so.
Okay. Campbell, can you tell us how it is that a trust can offer asset protection to an investor?
Yes. There's been some amendments, and the asset protection is often, that concerns most people, is often matrimonial asset protection as well as insolvency protection. I can say that matrimonial protection, it offers very little in that. The family court will go right over the top of trust and simply, for the most part, ignore them.
So in the event that, let's say, for example, someone owns a trust, they have assets in it, they get married, then, God forbid, they get divorced, then really the family law court has precedence over the trust.
They assert a precedence over the trust, a dominion and a paramountcy that the trustee would deny, but nevertheless the court enforces. And it does so in two ways. The first is the family court will say of, generally of the husband, he's usually the feckless guy who's controlling the trust, the family court will say either, all right husband, I want you to cause the trust to transfer to the wife these properties. And if the husband doesn't do it, the husband can be jailed until he does. So it's not an attack on the trust, it's still an attack on the husband. The second way it often happens, and this is more so where there's assets separately held by the husband and wife outside of the trust, is the court will say to the husband, all right, I'll treat all of those assets as yours, but out of the whole family division pool of assets, everything else is the wife's. So you can transfer the trust assets to the wife or not, but you're going to be treated for division purposes if you are.
Okay.
And that's often quite a strong... They don't have to attack the trust directly. They can if it's controlled by the husband or wife. But they don't have to do that in most cases.
Okay. From the point of view of, let's say, me owning a trust,
yes,
and I have several properties in a trust,
yep,
and I go ahead and do something and someone sues me,
yep,
they can't really touch what's in the trust, can they?
Generally not. Now, this is the insolvency limit. Bankruptcy law has been amended over the last few years to make trusts more accessible to creditors and the trustee in bankruptcy. That was introduced as a result of the some very bad bankruptcies in Queensland some years ago. And there's an extension to 4 years of a relation back if you transfer assets into a trust, or forever if it's said to be done fraudulently with intent to defraud creditors. But leaving aside questions of that, if you form a trust and it buys assets at arm's length from someone else, and that trust is, and the work you do for that trust is paid for by the trust. You're not doing work gratis for the trust. So any work that you do, and if you're managing the property, for example.
And this payment doesn't necessarily have to be physical payment. It can be payment in the form of a paper entry.
Yeah, so long as it's real. So long as it's real, yes. There must be consideration for services. But if you have a letting agent, that's not likely to arise because you're paying that anyway. And if that is the case, then generally the trust assets will be inviolable against the trustee in bankruptcy or the liquidator of the trustee company. And so that by this process, unless the trustee has traded insolvently or the directors have caused the company to enter into a non-commercial arrangement of some sort, this applies to every company, whether trustee or not, then the trust assets cannot be assailed. There is a case that came up from Western Australia who sheeted home to a director a liability because he controlled the trust and therefore made accessible to creditors, so the court held, the trust assets for division amongst them. Not a good decision, not one that makes any equity sense, and I think is something of an aberration. But broadly, so long as you stick with the rules that you don't do any uncommercial transactions, the assets you buy not from yourself or anybody else that's related to you, there's arm's length dealing, then for the most part there will be no attack on the trust. Now, if you are the trustee, you are personally the trustee, and you've incurred those debts, of course you'll go bankrupt, and that'll be subject to a sequestration order against your estate, and there would be a right of recoupment out of the trust assets to you as a person who, as trustee, you're entitled to recoupment. And if the trustee becomes liable because it's incurred debts on behalf of the trust assets are available to the trustee in bankrupt, well, if an individual or a liquidator, if a corporate, because that's a right of recoupment. The trustee is indemnified. One thing I will add here, and that is this, that if there's a change of trustees under which a new trustee is appointed and the old trustee retires, and that can be either through an appointer or just voluntarily or by agreement, the new trustee is not liable to the creditors of the old trustee, but a liquidator of the old trustee may be entitled to exoneration from the new trustee. It's one of the indemnities. Exoneration from the new trustee to satisfy the debts the old trustee incurred within power, where he no longer has the assets. That gives a proprietary interest in the old trustee to enforce against the new one to recover debts the old one's incurred within power.
What does that mean?
It means that depending on how the trust deed is drawn and how the deed of appointment of new trustee is drawn, the new trustee may or may not be liable for debts of the old one. And the liability would be to a liquidator of the old one, or someone acting as the proper authority, could be the directors of the old one, but someone, whoever the proper organ is of the old one to collect in the debts in insolvency. Then the new trustee could have to fess up to whatever assets it took over from the old trustee to satisfy those earlier debts.
Okay.
That's a right of exoneration, and it seems to me there's a division of opinion here. My view is you can limit it to assets only in your possession, but there's another view that says you can't. So caution and prudence says that it's you don't want to argue the public policy question of saying that you can limit it if your trust deed is better drawn.
Okay. Let's just pause. So Campbell, let's assume that I have a business.
Yes.
And I have a trust that has some properties in it.
Yes.
And for some reason my business goes bankrupt and the business is totally separate to the trust.
Yes.
In that case, would I be correct in assuming that the assets within that trust couldn't be touched by the creditors that may be coming after the business?
Yes. In the way you put it, if there's no connection at all and the trust assets have not been pledged to the business owner carried on or to its creditors, then yes, you're right.
Okay. And how would a trust need to be set up to ensure that would be the case?
The steps would be these. First, under the trust deed, limit the powers of the trustee so it could not give financial assistance and could not undertake services for payment or not to the business corporate, if assuming it's a company, the business corporate itself, so that there's no power in the trust deed, and hence the trustee, to engage itself, entangle its operations with that of the business conducted or the company conducting the business. If that happened, That is, if you drafted the trust deed in that way, then any debts that the trustee somehow engaged itself in would not be liable for recoupment because they wouldn't have been incurred within power of the trust instrument. And therefore there'd be no right in the creditors of the business or its liquidator, by subrogation to him, to recover assets of the trust. I mean, this is a fairly unusual circumstance, and it would be an extreme case where you would actually have to plan for that added protection because it's just not likely to rise if they're truly separate. But if you did, then a limitation on the trust's capacity to give financial benefits to the company or to engage itself in a way that creates liabilities on the company to the trust, then if that's not within power of the trustee, then the creditors are not then able to recoup. However, the trustee of the trust may still be liable.
But if the trustee's a corporate trustee and is worth $10, a $10 company,
exactly,
then they could essentially go after the $10.
That's all, because the creditors, if they wind up the corporate trustee, they will get nothing from the trust because there was never power in the trust deed for the corporate trustee to entangle itself with the corporate trader.
And then an appointor could simply decide what the new trustee, elect or find another new trustee?
Yes, either an appointor or can just voluntarily resign and appoint a new one. The appointor matters very little here.